Madam, please begin.
बदलाती तो नहीं कैसे काम नहीं है.
Okay, sir.
और तो सर
Priyanka, madam, please begin.
Yeah. A very good afternoon to one and all gathered here. I, Priyanka Pradhan, Faculty of Parul Institute of Business Administration, member Electoral Literacy Club, Parul University, would like to welcome you all in the Parul University's live webinar session. The other moderator for the webinar is Dr. Rekha Parmar ma'am, member of PU Electoral Literacy Club, Parul University. Education is not preparation for life. Education is life itself. Education is having a thirst for knowledge and the ambition to take your learning to the next level. The beautiful thing about learning is that nobody can take it away from you. With this, I would like to welcome Honorable Resource Person of the Day, Dr. Dinesh P. Kapadia, sir. I would like to welcome Professor Om Prakash Shukla, Chairperson, PU Electoral Literacy Club, Parul University. Last but not the least, I sincerely welcome all my students and faculty colleagues. The Loktantra, PU Electoral Literacy Club, under the banner of Technical Events Cell, has been established in Parul University with a vision to make its utmost contribution to have an active democratic citizenry originated in integrated civic and voter education and electoral participation right from a young age. The Election Commission of India is the nodal authority established under the Constitution of India, responsible for conducting elections in India. The voter strength is in India accounts for almost a glaring 900 million voters, which is way more than the other democracies around the world. Every year, the voter strength increases in India with a significant number of youths crossing the age limit of 18 years and becoming eligible to vote. Today is the wonderful day as amongst us. Today we have a recognized expert, Dr. Dinesh P. Kapadia, sir. It's my pleasure to have you here, sir. Honorable Speaker is having 30 years of working experience in different capacities in different departments, Secretariat, Gujarat State, India. Dr. Dinesh P. Kapadia, sir, presently working as a member, Consumer Disputes Grievance Commission in Sabarkantha District, Himmatnagar Government of Gujarat. He is an independent member, Consumer Grievance Forum, UGVCL, Gujarat Electricity Regulatory Commission, and a retired Joint Secretary, Government of Gujarat. Dr. Dinesh Kapadia, sir's educational qualification comprises of BSAM, LLB, MA, PhD in Sociology. He is qualified gender resource person. Sir had presented various national and international level papers in various conferences, as well as delivered academic sessions in state, national, and international level institutions. We welcome you, sir. Our today's topic is awareness of election law in India. Sir, I would like to invite you to share the knowledge about the topic awareness of election law in India. Thank you so much, sir, for accepting our invitation. Now, sir, you can share your knowledge and you can start.
Okay, thank you very much for getting an opportunity to share my views on introduction of election law in the context of India. And in the beginning, I must make it abundantly clear that I am not a legal luminary, nor I am an expert on this subject. Frankly speaking, being a government officer and having served in different departments in different capacities, and lastly, Director Gender Resource Center and Additional Commissioner in the Women and Child Development Department, I would like to describe myself as a jack of all and master of none. But within my limitation, I shall try to justify my presence today. Again, I would like to thank you all. So let us now begin with the Constitution and Election Commission of India. As you know, the Article 324 provides for setting up of Election Commission, and it's the duty of Election Commission to ensure free and just election in our country. The Election Commission of India is vested with the power of superintendence, direction and control of elections to Parliament, state legislation, President of India and Vice President of India also. And Chief Election Commission and other election commissioners' appointment in our country. The appointment of Chief Election Commissioner and other members of the Commission, as per Article 324 of the Constitution, is actually done by the President of India. But as we know, that President has to perform his duty in consultation with the Council of Ministers of the central government. And therefore, realistically speaking, the appointment of such a crucial election body is solely in the hands and to the desire of the executive, that is the central government and the party in power. The Constitution has not prescribed the qualification of the members of the Election Commission. That is somewhat disgusting. But anyhow, the election commissioners are mostly retired IAS officers, so there is no problem. And the Constitution has not prescribed qualification. Not only that, Commission has not debarred the existing election commissioners from gaining any office of profit after debiting their office. There is also no bar regarding there is no actually guidelines with regard to dividing the responsibility and assignment of work between the main boss, that is Chief Election Commissioner, and other members of the Commission. And presidential election, let us discuss about it. The Article 54 of the Indian Constitution provides for election of the President of our country. An electoral college consisting of both the houses of parliament, it means the Rajya Sabha, that is known as upper house, and Lok Sabha, that is known as the lower house. And as per Article 55, state includes not only bigger states, but it includes the Delhi government, which is a small government, National Capital Territory of Delhi, and Union Territory of Puducherry also. The president must be at least 35 years of age. The manner of election of president as per Article 55 is somewhat confusing, somewhat cumbersome, and somewhat difficult to understand for all of us. For me also, of course. Every elected member of the Legislative Assembly of a state shall have as many votes as there are multiples of 1,000 in the quotient obtained by dividing the population of the state by the total number of the elected members of the assembly. If after taking the state samples in multiples of 1,000, the remainder is not less than 500, then the vote of each member shall be further increased by 1. Each elected member of either house of parliament shall have such number of votes as may be obtained by dividing the total number of votes assigned to the members of the Assembly of the state by the total number of the elected members of both houses of parliament, that's Rajya Sabha and Lok Sabha. Fractions exceeding 1/2 of that is not to be counted. The system of proportional representation by means of a single transferable vote and the voting by secret ballot. It means if there are more candidates, then each member of parliament, the legislative assembly, has to give preference. Number 1, number 2, number 3, etc. In number 1 is most important, and in case of tough competition and contest, then second preference is also taken into consideration. Mostly president election doesn't become so competitive in our country. That's a good thing. And qualification for president, as per Article 58 and 59, he must be citizen of India. Age not less than 35 years, must be qualified for election as a member of parliament. The president should not hold any office of profit. The president not to be a member of each house of parliament or of a house of the legislature of any state, and if he is so, after getting into his office, has to limit that. So then vice president election, as you know, the vice president of India is chairperson and presiding officer of upper house, that is Rajya Sabha. The electoral college for election to the post of vice president consists of all members of both the houses of parliament, that is Rajya Sabha and Lok Sabha. The vice president should not be a member of either house of parliament or house of the legislature or state. And if a member of either House of Parliament or any House of Legislature of any state has to limit his membership, a person cannot be elected as vice president unless he is a citizen of India, has completed the age of 35 years, and is qualified for election as a member of Council of States as Rajya Sabha. Minimum, then a person is also not eligible if he holds any office of profit under the government of India or state government or any public sector. What is parliament? The definition of parliament has to be understood by every law student that parliament doesn't mean only Lok Sabha and Rajya Sabha. Parliament means the president, Lok Sabha and Rajya Sabha. That is the correct legal definition of parliament. That is as per Article 79 of the Constitution. Article 80, membership in the Rajya Sabha is limited to 250 members. This total number of members in the Rajya Sabha is maximum 250. And out of these 250 members, 238 members are elected by the members of all the Vidhan Sabha, that is state legislative assemblies, and up to 12 members of Rajya Sabha are nominated by the President of India for their contribution in various fields like art, literature, sports, science, and social services, etc. As we know, that Mary Kom, Sachin Tendulkar, Lata Mangeshkar, they were all not elected members. They were actually nominated by the President of India because of the contribution in their respective field. Article 81 of the Constitution defines the composition of the House of the People or Lok Sabha, and not more than 550 elected members, of whom not more than 20 would represent various union territories in our country. This is Lok Sabha, it's known as lower house, and there is direct election by the people of our country for membership of Lok Sabha. Then we would like to go to Representation of People's Act 1951, which is popularly known as RPA, that provides for conduct of elections of the houses of parliament and to the houses of various state legislative assemblies, that is known as Vidhan Sabha. Details about the structure of administrative machinery for the conduct of elections, qualification, disqualification for membership of the houses, corrupt practices, and other offences or in connection with such elections and decisions, doubts, and questions, query, disputes arising out of or in connection with the elections. These all have been provided in the RPA Act 1951, Representation of People's Act. And there is also spending limit for members or for candidates of Lok Sabha and state legislative assembly, and it has been recently suitably amended a few years ago. So for Lok Sabha elections, the spending limit for a contesting candidate is 95 lakhs in bigger states and 75 lakhs for smaller states like Manipur, Tripura, etc. And for state legislative election, a candidate contesting election to the state legislative assembly, the spending limit has been fixed at ₹40 lakhs in bigger states and ₹28 lakhs in smaller states. Of course, we all know that in reality, these spending limits are not maintained, but I would not like to discuss it because it's a matter of controversy. And qualifications under the Constitution for Lok Sabha candidates: if he or she is of unsound mind, cannot contest Lok Sabha election. If he or she is declared insolvent, and if or she is not a citizen of India and has voluntarily acquired a citizen of a foreign country. Of course, now there is an amendment. So NRI, even if they are not in the electoral list, can apply for voting right and get them registered in the electoral roll. There's a new amendment, which I must mention here. And this qualification under Representations of People Act, if found guilty of election offenses, financial offenses, corrupt practices, as for example, the BR ex-chief minister, I wouldn't like to name him, you would know him all. He has been barred from contesting election to Assembly and Lok Sabha because of corrupt practices in one of the very famous scam, which is known as Ghas Chara Ghotala. So now he cannot fight any election because of his conviction by competent court of law. And other thing which I must mention, if a candidate failed to lodge an account of his election expenses within stipulated time limit by the election commission, he cannot contest the next time election. He is barred from doing so for 6 years. Having interest in government contracts, works, and other services, if dismissed from government service on corruption and other serious charges like molestation, rape, etc., if punished for practicing and preaching social disorders and social evils like sati, untouchability, misogyny, etc. Election office covered under Representation of People's Act. Any person in the service of the government for the furtherance of the prospects of that candidates, any form of gratification, these all are election offenses under Representation of People's Act. And if anybody is found to indulge in such type of election offenses, suitable actions are taken under provisions of this Representation of People Act and other legal law, especially Indian Penal Code also. Candidates for withdrawing or not withdrawing nomination, of course, any pressure on any candidate through force, money, and muscle power, this is also considered to be a corrupt practice. Appeal to voter to refrain from voting on the ground of religion, race, caste, community, and language, etc. The promotion of feelings of enmity and hatred between different groups of people. This is also one of the corrupt practices and election offense covered under the RP Act. Then booth capturing. Other offenses are also there, but for want of time, I wouldn't like to mention it here. Then certain election reforms have been recently carried out. What are these election reforms? We must ponder over it. Model code of conduct. Earlier, there was no model code of conduct prior to 1971 general elections to the Lok Sabha. And for the first time in the history of independent India, Election Commission of India announced model code of conduct. What is model code of conduct? That most of you know that once elections are officially notified by the Election Commission of India, the ruling party cannot announce any welfare measures for the people to attract them for the ruling party's election campaign. The code has been revised from time to time, and it has laid down certain guidelines also. As we know, then the late T.N. Seshan, when he was Chief Election Commissioner of India in the 90s, he made this model code of conduct very strict. He implemented it so stringently that most of the political powers, especially those who in power, were totally fed up with him. But it is the reason why he is considered to be father of election in independent India. He had really done a very commendable job by proving what is the power of Election Commission of India. If Election Commission of India implement all model code of conduct properly and honestly, then there is no chance for dishonesty, unfair practices during election. But it depends upon awareness on the part of electorate. And I think your unit is doing so by creating awareness on election. And this should be part of your agenda and syllabus also. The people should be aware. Harold Laski, very rightly observed, well-known political scientist, the price of liberty is eternal vigilance. You cannot achieve liberty without continuous and perpetual awareness among various stakeholders and target group. So, other model code of conduct, in order to ensure that the parties practice internal democracy in their functioning, the commission took certain measures to ensure that organizational elections within the party were conducted well on time and periodically, and this has to be placed on records and it has to be submitted to the Election Commission. EC has also fixed legal limits. I have already mentioned it on the spending money during election campaign. However, one thing must be mentioned, that individual candidate has to observe this financial limit, spending limit. But political party is not supposed to observe this expend limits. That is a lacuna. So every political party, when it announces the names of its star speakers, expenditure incurred on their meetings is not considered to be part of a candidate's election. That is a lacuna. In an attempt to improve accuracy of electoral rolls, the Election Commission in 1993, actually for the first time in our country, election card, that is known as EPIC. That is very important. Every voter has to obtain election card from the Election Commission of India. Then dilution of these qualifications. These are certain points which we must bear in mind, that despite stringent measures initiated by the Election Commission of India and under legal provision, especially under Representation of People's Act, Supreme Court of India once took a serious note of these stringent actions, and section in a very popular case is the Lily Thomas case of 2013, which invalidated section 8/4 on the grounds that it is against the principle of equality as envisaged under Article 40. And Parliament tried to bring an amendment to save section 8/4 by giving a cooling off period of 90 days. What is this section 8/4 of the Representation of People Act? Is that if anybody is convicted by competent court, then he cannot fight any election for 6 years. This was challenged by some candidate, and Supreme Court had taken a lenient view, and later on the party, other political parties also were in favor of allowing the persons who have been convicted by the court. So there is some dilution. That's the reason why I have prepared this title, dilution of these qualifications. Dilution of office of profit clause has also been observed in multiple cases where persons holding important political position, like MLA, member of Lok Sabha, they are sometimes offered various posts by the government, ruling party. Delhi government had made a number of parliamentary secretaries, but that was challenged, and now they have withdrawn their action. Noteworthy amendments will also have to be pondered over today in the context of this program under Representation of People's Act 1951. Insertion of section 126A, which banned publishing exit poll till the time of elections were over. So before election were over, so means voting was over, finally in various phases, no exit poll could be announced. This is very important. And section 8/4, which allowed convicted MPs and MLAs to stand for elections, filing a complaint was, it is now repealed, that once a person is convicted by the court, he prefers an appeal before an upper court. And under these circumstances, he can contest election, but now it is not possible. Insertion of section 62(2), which allowed a person post detention to contest election as is no longer ceased to be an electoral role, as his name is very much there. The recent amendments included very, very important, that is 20A of RPA, which now allows NRI to vote from their current presence via postal ballot system. I have mentioned it in my earlier slide, that now NRI can also use their franchise by undergoing certain procedural formalities. Then nota button. You must be knowing about what is nota. So now instead of boycotting election, voter can press nota button to express his disappointment against the existing government and system, that I don't want to vote. But he has to place it on record on the EVM. So that's a recent amendment, of course. And there is sometimes confusion, even among the junior government officers. There is a representative of Election Commission of India in our state and in other states also. And he or she is known as Chief Election Officer. Chief Election Officer means he is representative of the Election Commission of India. But there is another body which is known as State Election Commission. So this is a fine difference which is required to be understood by law students and also those who appear for competitive examinations like GPSC and UPSC. So there is a difference between Election Commission of India. Election Commission of India conducts election to Lok Sabha, Rajya Sabha, President, Vice President. There is State Election Commission in each and every state is appointed as per Article 243K. So elections to the local self-government, such the duty of State Election Commission. In our state also, retired IAS officer Mr. Sanjay Prasad of 1986 IAS batch is State Election Commissioner. And duty of State Election Commission under Article 242K is to conduct elections to the local self-government, the municipal corporations, municipalities, the district panchayats, the taluka panchayats, means block level elections, and gram panchayats also. In short, Panchayati Raj system election is conducted by the State Election Commission. And we have to discuss anti-defection law also in the context of today's event. Constitutional Amendment Act 1985, that was 52nd Constitutional Amendment. It was carried out by the late Rajiv Gandhi government in 1985. The 10th schedule of the Constitution. What is this? A brief summary and disqualification on the grounds of defection. The crux of the legislation specifying factors on which a member could be disqualified from Parliament or State Assembly if he or she voluntarily gives up membership of such political party. Then the member votes or obtains from any crucial voting contrary to the directive which is known as whip given to him by the party in power or any other party. And if this whip is violated by him, then it is considered to be an offense under anti-defection law. This is just to ensure discipline. And this is also aimed at preventing the most immoral act of Ayaram Gayaram. Defection is in our country popularly known as Ayaram Gayaram because of that Haryana incident. I have shown this picture also to drive my point, at my point that to ensure defection, money power is mostly used and allurement to give some important posting also. That is still going on, but I wouldn't like to discuss it here. And after being elected as a representative of a certain political party, if he or she joins any other political party after the election, then he is liable to be disqualified under various provisions of the anti-defection law. Anti-defection law and exemption. In 91st Amendment Act 2003 exempted disqualification arising out of split with 1/3 of the members defecting from particular political party. This qualification on the ground of defection not to apply in case of merger of splinter groups, provided if the said merger is with 2/3 of the members of the splinter group, legislative party who have contested to merge, who have consented to merge with other political party. In short, the anti-defection law has also certain lacunas. Sometimes legal luminaries, legal experts, social reformers also remark that in our country, retail defection is an offense. I would like to repeat, retail defection is an offense, but wholesale defection is not an offense. Then chairman or the speaker, decision-making authority in case of defection, the decision on questions to disqualification on the ground of defection means under anti-defection law. The chairman or the speaker, the respective legislative house, is the ultimate and final authority in taking a decision with regard to it. No court jurisdiction in case of disqualification of a member, decision taken by speaker. However, court can intervene under constitutional article 32, 226 and 137. But in most of the cases, speaker's decision is final. And there is also one lacuna that any complaint against anti-defection is filed before the speaker. There is no time limit. He can take decision on his own. He can take his own time. So sometimes if any legislature member, if he defects to other party out of allurement of money or any other post, or for any reason, he may continue to be a member of the assembly till an appropriate decision is taken by the speaker. And the speaker sometimes indulges in an inordinate delay. It is observed in some of the cases, but I wouldn't like to provide you any specific example of it, since I would like to avoid any controversy. So these are the anti-defection law, and within the stipulated time limit given to me, I have tried to provide you a glimpse of election laws in our country. And whenever I am given a short time, I remember William Shakespeare, brevity is beauty. अगर आप अपना काम बहुत कम समय में करके अपना मैसेज सही ढंग से सेंड कर सकते हो, इससे ज्यादा कोई सौंदर्य नहीं है. I think this is adequate in the context of today's event within stipulated time limit. And if you have any doubt, any query, question within my limitation, I shall try to satisfy you. Thank you all for giving me a patient hearing. V.V. John, late V.V. John. They had once written in the Indian Express, if anybody speaks on the same subject for more than a minute, he is in danger of boring at least somebody in the audience. I do hope I haven't bored any one of you. Thank you.
Thank you so much, sir, for sharing your valuable knowledge and experience with us. Sir, now I would like to ask few questions regarding the topic, which few students are asking. Sir, the first question is, who is regarded as father of elections in India?
Yeah, actually, two persons are regarded as father of election. First, I would prefer the name of the first election commissioner of India, Sri Kumaran. He was retired IAS officer. It was a daunting task to conduct first general election way back in 1952, because ground level difficulties were there, bottlenecks were there, and logistical supply was also inadequate. Despite all odds, with paper ballots, he conducted the first general election to Lok Sabha way back in 1952. Today, election commission is provided lot of fund. It is not audited by CAG also. So all facilities are enjoyed by the election commission officers. But in 1952, logistical support was not there. Despite all odds, he really conducted elections in a manner which was a part of duty. And that is the reason why Mr. Kumaran, and other name is T.N. Seshan. Because when elections were considered to be a matter of exchange of money and other malpractices during election, it was T.N. Seshan who implemented moral code of conduct so forcefully and stringently that for the first time after independence, people realized what is election commission.
Okay, thank you so much, sir, for your response. Sir, now my next question is, sir, is India is a unitary or federal state according to Indian Constitution?
If you read the preamble of the Constitution, and if you read the relevant articles of the Constitution, you will realize that India is neither a unitary nor a federal state. Because the President of India is the Commandant General of all the three forces of armed force, our Army, Air Force, then Navy, and the infantry. So it's the Commandant, Supreme Commandant General. So this is actually characteristic of a unitary state. But in our constitution, there are different states, and three lists are there. One is central list, other is state list, and concurrent list. So power is divided among the state as well as the center. So for all practical purposes, we can come to a conclusion that India is neither a unitary nor a federal state. It's a blend of unitary and federal state.
Okay, sir. Thank you, sir, for making us understand about this. So it's a blend of both unitary as well as federal state. Okay. Sir, my next question is, sir, who is appointed as returning officer for the election of president?
Yeah. Normally, a Director General of Lok Sabha or Rajya Sabha is appointed as returning officer to conduct election of the President of India. That is convention, of course. There is no rule, but in convention is there. Director General of Lok Sabha or Rajya Sabha is appointed, returning officer.
Okay, sir. So my next question is, sir, what is adult franchise?
Adult franchise means the minimum age of a voter. Earlier in our country, it was 21 years. But there has been now amendment, and since 1990, a person who is eligible to use his franchise means right to vote is now lower down to 18. So any person who is of 18 or more than that can use his franchise. That is adult franchise. Yeah, I think it is now clear.
Okay, fine, sir. Thank you, sir. Sir, my last question to you is, sir, can you please throw some light on the stages of election? That what are the different stages of election that we have to follow?
Yes. After the expiry of full term of Lok Sabha or state legislative assembly, which is 5 years, the Election Commissioner of India issued official notification for election. And after notification issued, that is the first stage. So now elections are surely going to be conducted in a particular state or Lok Sabha. So first is issuance of notification by the Election Commission of India. And as per convention, there should be a gap of 50 days between the date of notification and actually conduct or date of the election which takes place on particular date. This is the first stage is notification, then filing of beginning of filing of nomination by the candidates, then the last date for filing nomination, then the last date for withdrawal of candidates from the election, and then decision regarding scrutiny of the candidates' application, and then permission to the various political parties to conduct their campaign. The last day of a campaign, normally it is 3 days prior to the date of election, then voting, and the last stage is counting of voting, official declaration of the results, and once the results are finally declared and certificate of election is issued to a successful candidate, whether it is assembly or Lok Sabha, then the election process is over. These are the mostly 4 to 5 phases are there. These are part to conduct. These are considered to be various phases of the conduct of election in our country. And once it is officially announced by the Election Commission that the election process is over, then the model code of conduct is also over.
Okay, sir. Thank you so much, sir, for explaining us so nicely about the stages of election. That's all for today regarding the question and answer round. Thank you so much, sir, for spending your precious time and accepting our invitation. Now I would like to invite Dr. Rekha Parmar, ma'am, to extend vote of thanks.
Maybe Rekha ma'am is not with us. Sir,
Namaskar.
Namaskar.
Audible, madam?
Yeah, now you are audible, yeah.
Namaskar. I am Dr. Rekha Parmar.
Okay.
I would like to thank respected Dr. Dinesh Kapadia sir on this auspicious occasion of webinar on awareness of election law in India. We are very fortunate enough to have amongst us the well-known personality Dr. Dinesh Kapadia sir, Joint Secretary, Government of Gujarat. This webinar is organized by Electoral Literacy Club under Technical Event Cell, Parul University. Dr. Dinesh Kapadia sir has enlightened us in election law in India. He has in-depth knowledge in this area. Sir has delivered excellent lecture on this topic and made us aware about it. Lecture was very lucid and understandable even to the layman. So I thanks a lot to Dr. Dinesh Kapadia sir on behalf of Parul University for delivered the lecture and giving their precious time to all of us. My special thanks to Dr. Ravi Pandya sir, DYMS Parul Ayurveda University for suggesting Dr. Dinesh Kapadia sir as a speaker. Once again, thanks a lot all those persons who are involved directly and indirectly in these events. Thanks a lot. Jai Hind.
Okay, thank you. All.
Now we can conclude this session. Thank you very much.
Okay, thank you all.
thank you, sir, for
Thank you.
joining with us.
Yeah, thank you. Thank you.
Sir, you can leave the session.
Yeah, okay, thank you.
Sir, just a minute. Sir, as a
Bolok